Mode of registration incorporation of company. Promoters. The Company Act 2013 defines the term promoter under Section 269, which means a person who has been named as such in a prospectus or is identified by the company in the annual return referred to in Section 92, or who has control over the affairs of the company directly or indirectly, whether as a shareholder, director, or otherwise, or in accordance with whose advice, directions, or instructions the board of directors of the company is accustomed 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 to act. In simple terms, we can say persons who form the company are known as promoters. This it is they who conceive conceive the idea of forming the company. They take all necessary steps for its registration. It should, however, be noted that persons acting only in a professional capacity, example, the solicitor, banker, the accountant, etc., are not regarded as promoters. Formation of company. Section 3 of the Companies Act 2013 deals with the basic requirement with respect to the constitution of the company. In the case of a public company, any seven or more persons can form a company for any lawful purpose by subscribing their names to memorandum and compiling with the requirements of these act in respect of registration. In the same way, two or more persons can form a private company and one person can form one person company. Public company, seven or more persons. Private company, two or more persons. One person company, one person. Incorporation of company. Section 7 of the Companies Act 2013 purposes subscribing their name to memorandum and compiling with the requirements of these act in respect of registration any lawful. In this case, a public company, any seven or more persons can form a company for any lawful purpose by subscribing their names to memorandum and compiling with the requirements of this act in respect of registration. In the same way, two or more persons can form a private company and one person can form one person company. Public company, seven or more persons. Private company, two or more persons. Uh, more persons. One person company, one person. Incorporation of company. Section 7 of the Companies Act 2013 provides for the procedure to be followed for incorporation of a company. Filing of the document and information with the registrar. For the registration of the company, following documents and information are required to be filed with the registrar within whose jurisdiction the registered office of the company proposed to be proposed to be situated. The memorandum and article of the company duly signed by all the subscribers to the memorandum. All all declaration by person who is engaged in the formation of the company, an advocate, a chartered accountant, cost accountant, or company secretary in practice, and by a person named in articles, director, manager, and secretary secretary of the company, that all the requirements of these act and the rules made thereunder in respect of registration and matters transient or incidental thereto have been compiled with a declaration a declaration from each of the subscribers to the memorandum and from persons named as the first directors, if any, in the articles, starting that he is not convicted of, of any offense in connection with the promotion, formation, or management of any company, or he has not been found guilty of any fraud or misfeasance, or of any breach of duty to any company under this act or any previous company law during the last 5 years, and that all the documents filed with the registrar for registration of the company contain information that is correct and complete and true to best to the best to the best of his knowledge and behalf. The address for correspondence till its registered office is established. The particulars, names including surnames or family names, residential address, nationality of every subscriber to the memorandum, along with proof of identity, and in the case of a subscriber being a body corporate, such particulars as may be prescribed. The particulars, name including surnames or family names, the the director identification number, residential address, nationality of the persons mentioned in the articles has the subscribers to the memorandum, and such other particulars including proof of identity has may be prescribed, and the particulars of the interests of the persons mentioned in the articles as the first directors of the company in other firms or bodies corporate, along with their consent to act as directors of the company in such form a manner as may be prescribed. A manner uh, and manner has may be prescribed. Particulars Particulars provided in this provision shall be of the individual subscriber and not of the professional engaged in the incorporation of the company. The Company Incorporation Rules 2014, issue of certificate of incorporation on registration. The registrar, on the basis of documents and information filed, shall register all the documents and information in the register and issue a certificate of incorporation in the prescribed form to the effect, effect that the propo- proposed company is incorporated under this act. allotment of corporate corporate identity number CIN on and from the date mentioned in the certificate of incorporation, the registrar shall allot to the company a corporate identity number CIN, which shall be a identity number, distinct identity for the company, and which shall also be included in the certificate. Maintenance of copies of all documents and information. The company shall maintain and preserve at its registered office copies of all documents and information as originally filed till till its dissolution under this act. Furnishing of false or incorrect information, or separation of or separation of material fact at the time of incorporation, that is at the time of incorporation. If any person furnishes any false or incorrect particulars of any information, or suppresses any material information of which he is aware aware in any of the documents filed with the registrar in relation to the registration of a company, he shall be liable for action for fraud under section 447. Company He shall be liable for action for fraud under section 447. Company already incorporated by furnishing any false or incorrect information or representation, or by summarizing any material fact that is post incorporation, where where at any time after the incorporation of a company, it is provided that the company has been got incorporated by furnishing any false or incorrect information or representation, or by summarizing any material fact or information in any of the documents or declaration filed or made for incorporating such company, or by any fraudulent action, the promoters, the persons named as the first directors of the company, and the persons making declaration under this section shall each be liable for action for fraud under section 447. Order of the tribunal, where a company has been got incorporated by furnishing false or incorrect information or representation, or by summarizing any material fact or information in any of the documents or declaration filed or made for incorporating such company, or by any fraudulent action, and the tribunal may, on an application made to it, on being satisfied that the situation so warrants, pass such orders as it may think fit for regulation of the management of the company, including changes, if any, in its memorandum and articles and articles in public interest or in the interest of the company and its members and creditors, or direct that liability of the members shall be unlimited, or direct removal of the name of the company from the register of companies, or pass an order for the binding up of the company, or pass such other orders as it may deem fit, provided that before making any order, the company shall be given a reasonable opportunity of being heard in the matter, and the tribunal shall take into consideration the transactions entered into by the company, including the obligations, if any, contracted, or payment of any liability. Sim- Simplified pro forma for incorporating company uh, electronically. Spice. The Ministry of Corporate Affairs has taken various initiatives for ease of ease of business in a step towards easy setting up of business. MCA has simplified the process of filing of forms for incorporation of a company. The तरफ simplified pro forma for incorporating company electronically. Effect of registration. Section 9 of the Companies Act 2013 provides the effect of registration of a company according to Section 9 from the date of incorporation mentioned in the certificate of incorporation. The subscribers to the memorandum and all other persons who may from time to time become members of the company shall be a body corporate by the name contained in the memorandum. Such a registered company shall be capable of exercising all the functions of unincorporated company under this act, and having perpetual succession with power to acquire, hold, and dispose of property, both movable or immovable, tangible and intangible, to contract and to sue and be sued by the said name from the date of incorporation mentioned in the mentioned in the certificate. The company becomes a legal person separate from the incorporators, and there comes into existence a binding contract between the company and its members, as evidenced by the memorandum and articles of association. It Harinagar Sugar Miles Limited versus SS Jhunjhunwala. It has perpetual existence until it is dissolved by liquidation or struck out of the register. A shareholder who buys shares does not buy any interest in the property of the company but in certain cases a writ petition will be maintainable by a company or its shareholders. A legal personality emerges from the moment of registration of a company, and from that moment the persons subscribing the memorandum of association and other persons joining as members are regarded as a body corporate or a corporation in aggregate, and and the legal person being and the legal person beings to function as an entity. A company on registration acquires a separate existence, and the law recognizes it has a legal person separate and distinct from its members. State State Trading Corporation of India versus Commercial Tax Officer. It may be noted that under the provisions of the Act, a company may purchase shares of another company and thus become a controlling company. However, merely because a company purchases all shares of another company, it will not serve as a means of putting an end to the corporate character of another company, and each company is a separate juristic entity. इस Spencer and Co Limited, Madras versus CWT Madras, has as has been started above. The law recognizes such a company as a juristic person separate and distinct from its members. The mere fact the mere fact that the entire share capital has been contributed by the central government and all its shares are held by the President of India and other officers of the central government does not make any difference in the position of registered company, and it does not make a company an agent either of the president or the central government. Heavy electrical union versus state of Bihar. Effect of memorandum and articles has per section 10 of the Companies Act 2013, where the memorandum and articles when registered shall bind the company and the members thereof to the same extent as if they respectively had been signed by the company and by each member, and an agreement to observe all the provisions of the memorandum and of the articles. All monies payable by any member to the company under the memorandum or articles shall debt debt due from be a debt due from him to the company. Classification of capital. The term capital has a variety of meanings. It means one thing to economists, another to accountants, and still another to businessmen and lawyers. In relation to a company limited by shares, the word capital means share capital, that is, the capital or figure in terms of so many rupees divided into shares of fixed amount. In other words, the contributions of persons to the common stock of the company form the capital of the company. The proportion of the capital to which each member is entitled is his share. A share is not a sum of money. It is rather an it is rather an interest measured by a sum of money and made up of various rights contained in the contract. In the in the domain of company law, the term company is used in the following senses: a nominal or authorized or registered company. The form of capital has been defined in section 2 subsection 8 of the Companies Act 2013. Authorized capital or nominal capital means such capital has is authorized by the memorandum of a company to be the the maximum amount of share capital of the company. Thus, it is the sum stated in the memorandum uh, the capital of the company with which it is to be registered being the maximum amount which it is authorized to raise by issuing shares and upon which it pays the stamp duty. It usually fixed at the amount which it is estimated the company will need, including the working capital and reserve capital if any. Issued capital. Section 2, subsection 50 of the Companies Act 2013. Issued capital, which means such capital has the company issues from time to time for subscription. It is that part of authorized capital which is offered by the company for subscription and includes the shares allotted for consideration other than cash. Schedule 3 of the Companies Act 2013 makes it obligatory for a company to disclose its issued capital in the balance sheet. Subscribed capital. Section 2, subsection 86 of the Companies Act 2013 defines subscribed capital as such part of the capital which is for the time being subscribed by the members of a company. It is the nominal amount of shares taken up by the public where any notice, advertisement, or other official communication of communication or any business letter, bill, head, or letter, bill, head, or letter paper of a company states the authorized capital. The subscribed and paid up capital must also be stated in equally conspicuous characters. A default in this regard will make the company and every officer who is in default liable to pay penalty extending rupees 10,000 रुपए and 5,000 रुपए respectively. Section 60 called up capital. Section 2 subsection 15 of the Companies Act 2013 defines called up capital has such part of the part, part of the capital which has been called for payment. It is the total amount called up on the shares issued. Paid up capital is the total amount paid or credited has paid up on shares issued. It is equal to called up capital less calls in arrears. It is equal to called up capital less calls in arrears. Shares. Nature of shares. Section 2 subsection 84 of the Companies Act 2013 defines the term share, which means a share in the share capital of a company and includes stock. A share thus represents such proportion of the interest of the shareholders as the amount paid up thereon bears to the total capital payable to the company. It is a measure of the interest in the company's assets to which a person holding a share is entitled. Share is an interest in the company. Farewell justice. In Borland Trustees versus Steel Boards and Co Limited, observed that a share is not a sum of money but is an interest measured by a sum of money and made up of various rights contained in the contract, including the right to a sum of money of a more or less amount. You should note that the shareholders are not, in the eyes of law, part owners of the undertaking. The undertaking is somewhat different from the totality of the shareholders. The rights and obligations attaching to a share are those prescribed by the memorandum and the articles of a company. It must, however, be remembered that a shareholders shareholder has not only contractual rights against the company but also certain other rights which acquire to him according to the provisions of the Company Act. Share capital. Equity share capital, preference share capital with uniform voting rights with differential voting rights. Shares are a movable property according to Section 44 of the Companies Act 2013. The shares or debentures or other interest of any member in a company shall be movable property, transferable in the manner provided by the articles of the company. Shares shall be numbered. Section 45 provides every share in a company having a share capital shall be distinguished by its distinctive number. This this implies that every share shall be numbered. However, this shall not apply to a share held by a person whose name is entered as holder of beneficial interest in such share in the records of a depository depo, depository depository. Kinds of share capital. Section 43 of the Companies Act 2013 provides the kinds of share capital. According to provision, the share capital of a company limited by shares shall be of two kinds, namely equity share capital with with voting rights or with differential rights has to dividend voting or otherwise in accordance with prescribed rules. Example, it is to be noted that Tata Motors in 2008 introduced equity shares with differential voting rights called A equity shares in its rights issue. In the issue, in the issue, in the issue, every 10 A equity shares carried only one voting right but would get 5% point 5% 5 percentage points more dividend than that declared on each of the ordinary shares. Since a equity share did not carry the similar voting rights, it was being traded at the discount to other common